Hello, everyone. We are here today with Zach Anderson. He's an estate planning attorney with Brodowski, McCurry, Maynard, Miller. You have all the alphabets in there. That's awesome. Welcome, Zach. How are you doing?
I'm well, Derek. How are you?
I'm great. And as always, I'm Derek Mazzarella with Gateway Financial Partners. I'm a CFP, and today we're talking about estate planning. So a little intro on Zach. He attended the University of Alabama Law School, and he really enjoys working with business owners. So today's topic is going to be a little bit focused on trust and how do you go into retirement with a trust, what you should be thinking about as a pre-retiree and quite frankly, as a retiree. So why don't we just kind of start with the basics, Zach? So just give us a little bit of background on yourself. Tell us how you help people.
Sure, Derek. So I help people plan for the future on the legal side. I let you guys handle the finances side.
Yeah.
I stick to where I'm licensed. But a lot of people would say, how can you plan for so much with so much uncertainty, whether it's family uncertainty, Congress, politics, uncertainty. Well, I see a lot of certainty. I know two things are true. One, you're going to get older, and two, you're going to die. And we can plan for both of those things. And we need to, because I always say, you've got an estate plan right now. If you were to, Lord forbid, pass away right now, something's going to happen to your assets. Something's going to happen to it. They don't get frozen. So you have an estate plan right now. It's just not optimal, perhaps. And that's where I come in to help.
Right. You have the government's estate plan. You don't have the one you want, probably.
That's right. And
yeah.
that might be the one thing that everybody can agree on. They probably don't want that.
Correct. Mm-hmm. So Zach, what's a common misconception that you find that comes up frequently about estate planning?
Sure. There's so many, but I'll stick to the top one that comes to mind, and maybe another if I think of another. I would say that if I do nothing, it'll all just kind of wash out in the end. Mm-hmm. That is not accurate. There's plenty of examples of where that is just not, unfortunately, not the way it works. The first is the law. And we were talking about this a little bit before we got on, Derek. Your assets, where they go, if you do not have a last will and testament, trust, or some other instrument like that, where those assets go is determined by the law of the state that you resided in when you passed away. There are some surprises here. Let me tell you, there are some surprises here. People assume my spouse will get it all. That's not the way it works in Alabama. That's not the way it works in Alabama necessarily. And sadly, I see that issue a lot. I probate estates where I see that, and it causes a lot of disjointedness and lack of harmony in the family. I say on the planning side, I'm almost sort of like a unlicensed front-end counselor in that I'm seeing potential issues and I'm trying to make sure that you don't have to deal with them. Passing away without a will is really kind of the worst thing that you can do. At least if you have a will, you have the path to administer the estate, the path to go through probate court, and you've named how that path is going to go and who's going to lead, things like that. But without a will, it's all the law of the state that you reside in when you passed away. So the law is a big one. Secondly, passing away without a proper plan means we got to get court involved. I always say when people ask, what do? I say, I'm an attorney, but I try and keep my clients out of court. When we have to go to court, I go to court and protect my clients' rights, no questions asked. But I'd love to keep you out of court. I'd love to keep the court fees minimal. I'd love to keep the attorney's fees, my fees, hourly, minimal. I don't like court. People get stressed when they go to court. I don't. I'm a lawyer. But a lot of people do. And I don't want this to be your first experience in court dealing with a deceased loved one. That's not what I want. So the law, court, and then lastly, let's just briefly talk about the living will, Derek. The living will is a document that has a fairly narrow application. It's, at least in Alabama, it's when two doctors have certified that you are basically in a vegetative state. And at that point, the living will or advanced directive for healthcare is another, it's termed. You can spell out wishes, you can spell out proxies to help administer the document, be there for you, speak for you if you can't speak for yourself. If you don't have that, it could be bad. Your viewers may or may not be old enough to remember, or perhaps they've studied the tragic case of the Terry Schiavo.
Oh, yeah.
Where she was in a vegetative state. And not only did we have to go to court, and all this family's private business is in front of, I mean, forget the probate court of whatever county, this stuff is in front of CNN and Fox News and NBC and all this stuff. A living will would have avoided that. So thinking, if I don't do anything, I've got a basic family, I don't have a whole lot of assets, it's just going to wash out and work out in the end. I wish it were that way. It's not.
Yeah, I think a lot of people think you have to be a certain level of wealth to, need a will or need any of this stuff. But, to your point, every state law is different. You really want to make sure that your wishes are carried through. Will is a wish list. It's not the end all be all. And that's probably what we're going to get into a little bit too. Let's kind of talk about what we're here to talk about today. With trust, right? So estate planning itself can seem really complicated to the average person. I frequently have conversations. All right, well, maybe it's time for you to consider a trust. Maybe talking about to an attorney would be helpful. A lot of what I recommend tends to be revocable trusts. So can you give us an idea of, what a revocable trust is and what does it do?
Absolutely, Derek. So I like to point to one of my colleagues for just a straightforward definition of what a trust is, revocable and irrevocable, which we'll talk about both. But Christopher Small, an estate planning attorney in California, I believe, who I've learned a lot from his material online and elsewhere, he says the definition of a trust is a box. It's a box that you can put things into, take things out of, and direct rules about when things come out of the box, what are the rules that apply to it? Okay. That if you want protections in the trust for the beneficiaries, you can make rules for those distributions. So in many ways, a trust at its basic level is just a box that you can put things into. That's really kind of what it is. They're very, very on the revocable end. They're very customizable. And we can talk about kind of the main ways they're customizable if you'd like. But the rules for putting things in are really simple when you have a revocable trust. Revocable living trust is also a term for it. It's very straightforward. The IRS does not make a distinction between your revocable trust and yourself. You do not have a separate taxpayer identification number, no separate social.
Right.
You file your taxes the way you do before you had the trust. There's plenty of ways to customize the trust. Like I said, the first area we would look at is incapacity, disability. There's short-term disability. I like to somewhat keep it light, get hit on the head with a brick. Okay, that's short-term disability. We also have long-term disability. We have things like Alzheimer's and ALS. We can do a lot better than a basic power of attorney, which is still very important, but we can do better than that in a trust, determining disability and then administering the trust for the disabled trust maker's benefit, and then spouse and dependents as well, if we want to do that. So disability, if we have a married couple, the death of the first spouse, do we want all of our assets to go to surviving spouse? Do we want to plan for children? Do we want to plan for charities?
Well, let me jump in for a second too. I think one of the things that we're seeing more and more are blended families. So something like, oh, we both have kids from our first marriage. This is our second marriage. How do we divide that up? Those types of trusts can be very helpful in those instances.
Absolutely, Derek. There's a huge place for estate planning lawyers to add value when it comes to a blended family. So a blended family, to be clear, we have perhaps a second marriage, we have perhaps stepchildren.
Mhm.
Very, very common all across the globe at this point. We have a divorce rate nearing 50%. It's just something that an estate planning attorney has to be able to deal with. And one of the things we do is we have to have a candid discussion with both spouses. Do we want all assets going to the surviving spouse upon the first spouse's death? Do we want to put protections in place for protecting assets for kids? Because, you know, if you leave something outright to someone, you know, a surviving spouse, for example, they can go spend $10 million tomorrow on something. I don't know what $10 million is. Maybe a house in California. I don't know. But they could do it. We can put rules around that, just like we were talking about earlier. The trust is a box with rules in it. We can protect against that. Additionally, we can actually do some estate tax planning in a rev trust. Now, that's a fairly sophisticated tactic, but just a brief overview. The estate tax, federal estate tax, is 40% of whatever you leave to somebody after you pass away, with the exception of spouse and some other exceptions, charities. Right now, that exemption for a married couple is close to $24 million. There are state estate taxes that one must deal with if you're in a state like that. Massachusetts, I know, has a very small one. I believe it's $1 million.
Yeah.
Alabama does not have one. We also, quite frankly, in Alabama, don't have that many families above the limit, just to be clear. But that's something that you can actually do some contingent estate tax planning in a rev trust. So again, with the customization, that's not right for everybody. That's not right for me at that point. I don't have to worry about the FET, federal estate tax, at this point. But if we're nearing the high net worth level, whatever that means to you in your state, it's something we can look at. So just a lot of customization that you can do in the rev trust. And that's why my appointments, Derek, and I know I've probably been a little long-winded here. That's why my appointments, my first two, I always schedule them an hour and a half. I mean, we've got a lot of stuff to go over, and I've got to do a good job of making it clear and not make it seem like I'm pointing a fire hose at you and you're trying to just get everything you can and just stay alive.
Well, yeah, I mean, there's so many different variables and things. So, you know, I think part of both of our jobs is really, okay, there's all this information out there on the internet, and we can look up all of this stuff that we want to, but how do we filter this down to make it something that it's useful and proactive and beneficial for you? So that's one of our biggest challenges is for that. And kind of circle back up to the estate planning point. We were talking about this before too, is the limit is very high right now, but it can move, and it's going to sunset in a couple of years. So when that does, that number will drop significantly, and who knows what Congress is going to do. And, you know, as we mentioned, there's a lot of debt that they have and not a lot of different ways for them to collect revenue. This is an easy way for them to collect more revenue to pay down some of those tax burdens we have. So when it comes to, actually, I just want to make a quick distinction, because I know people hear wills and they hear trusts. It's like, well, why would I need a trust when I have a will? It already tells me everything, where I want the kids to go and what I want my house to go to and all this stuff. So why would I have a trust when I already have a will?
That's a great question. That's one of the most common questions I get, and it's also just conceptually a great one. The will in a trust-based plan, the will is there as a backup. Okay, so trust assets are non-probate assets. Anything you put into a trust, if it's designed properly, we're going to avoid probate court. We're going to avoid the expense and time and requirements of probate court. That's great. We also keep it public, or keep it away from the public with a trust. Probates, anybody can go to the courthouse or online, even in many counties in Alabama, and see probate records. Trust records are not the same. They are private. So you have the will as a backup. If you have assets that somehow don't get into your trust, maybe you inherited property right before you died and you didn't have time to deed it into the trust, then the will, it's called a pour over will, has to go through probate, and it simply pours all of the assets that go under the will into your trust. So it goes under the terms of, you know, your estate plan.
Right.
So when you have a trust-based estate plan, a rev trust, revocable living trust, you have the will there as a backup. Okay. By contrast, if you have a will-based estate plan, if you don't see the need for a trust, and some clients don't, if you don't see the need for it, then you wouldn't need a trust. The will would simply go through probate court. And the point of the will, this is very important, the point of the will is to make the journey through probate court as smooth and easy as possible.
Gotcha. Great. All right. So getting back to the types of trusts, you kind of mentioned to me there's some different types of trusts available, and so why don't we go a little bit of like, okay, going into retirement, what kind of trust should you be looking at or thinking about, depending on, I know you have a couple of situations you have examples for, or you want to give us an idea of what types of trusts there are?
Absolutely. So for the majority of clients that I work with, an estate plan based on either a will or a revocable living trust is going to be the best option for most of them. The revocable living trust that we talked about earlier does some really great things about avoiding probate court, keeping things private, getting beneficiaries their money faster, more sophisticated disability planning, and a couple of other important benefits. It's based on, your family, your goals. Do you see value in keeping it private? Where is your net worth? Is it in real property? If so, we can do a more simplified revocable living trust where we're basically just deeding real property into the trust. By contrast, do you have a lot of net worth in business interests? Do you have shares of a company that have appreciated rapidly? Do you have shares of a company? Do you have that old Apple stock from the Forrest Gump movie? Something like that. Do you have an airplane? I mean, where is your net worth? In that case, that would dictate us toward a more comprehensive, more complex trust that does more because it holds more assets and it holds more complicated assets other than real estate. Now, I want to talk a little bit about irrevocable trusts. And the thing that advisors and mortgage lenders and bankers and things think, their brain goes, high net worth clients, tax planning, things like clats and slats and grats and gruts and cruts and all these fun things. That is absolutely correct. You're right on the money. But there's one area that sneaks in where irrevocable trusts are really of great use. And I am seeing this explode in my market. And I bet you are too, Derek, as well as everybody probably across America. And that is nursing home planning. As a quick overview of this, Medicaid in many states, including mine, has become the nursing home payor of last resort. Okay. Now, that is not what it was designed to do, and that's not what it was intended to do. And no, it is not solvent. And we've got big issues, at least in Alabama, with regard to that. But the point is, if you are up there in age and you are going to need long-term care, okay, Medicaid will pay for a nursing home. They're not the greatest nursing homes, but I've been to many of them, and that's the proper care. If you don't have the level of assets that can sustain, $8,000 a month, $10,000 a month.
Quite frankly, you may not have the option either.
You may not have the option. And the quick answer is we can actually protect some assets before you go into the Medicaid nursing home. What Medicaid does is they have a clawback provision that allows them to recover the costs of providing you care. There's no constitutional right to long-term planning in the United States. So Medicaid will go after what it spends. And it can put a lien on your house once you're deceased, and it can foreclose on that lien. We can potentially salvage that. We can potentially save the house from Medicaid. They're clawing it back for the cost of services rendered. It can't work for everybody. The numbers have to be right in terms of where is your net worth. Okay, if you got a bunch of retirement accounts that have a lot of value, it's probably not going to work.
Mhm.
But if you're like a lot of people, including, quite frankly, my parents, Derek, that your net worth is basically your residence, long-term care planning, Medicaid nursing home planning is something that it flies under the radar for many estate planning attorneys, and to the great uh, uh, dismay of the public, because we can provide some serious value here, and that's a really growing area. So with irrevocable trusts, I'm seeing, yes, tax planning for the estate tax, but also long-term care nursing home planning.
Yeah, and that's important. And I think one of the things we should probably mention too is you can't just do this right before you go into a nursing home. This has to be planned well in advance. So if that's something that's concern of you, and I think when you're at that asset level, kind of like you mentioned, where it's mostly your house, maybe you have some smaller accounts, um, it's worth looking at, all right, my options either paying for this myself or the Medicaid route. And either way, it's better to have that planned out before you actually need the care.
Derek, I can tell, this is the first time you and I have gotten together, but I can tell you're collaborative because you are asking questions that most non-lawyers don't. And
Yeah.
you are exactly right. Medicaid will have what's called a look back period for transfers for less than fair market value. So yes, you cannot, as you're going into the nursing home, you cannot deed your son your house and get off scot-free.
Right.
That's
Here's
not
my
how
house
it
for
works.
$10. See you
For
later.
$10,
Yeah,
right,
I know.
right,
Yeah.
right. You can't do that.
Right.
So the earlier you plan, the better, with the caveat of sometimes we have what we call crisis planning. Crisis planning is mom is going into the nursing home right now, and we need to save whatever we can. And we need to do it in a way that's going to allow mom to live the best possible life that she can live.
Mhm.
That's crisis planning, and I can provide value there, but not nearly as much value as I can provide if you come see me a few years. When you feel yourself, and I get this question all the time. It's a tough one, but I'll attempt to answer it. When's the right time to look at long-term care planning? My answer, just my best answer, is when you feel yourself start to slip. That doesn't mean you're going into a long-term care facility. It doesn't mean you've been involved in a court proceeding. It just means when you start feeling like you're starting to slip mentally, it's time to come talk.
Yeah, great. Zach, really appreciate it. A lot of great information today. Last question for you. It'll be an easy one. How do people find out more about you?
Sure. So I am active on LinkedIn. You can search Zach Anderson, Huntsville, Alabama. You can also visit my firm's website. I'm at a great law firm, Brodowski McCurry. That's at brodowskiandmccurry.com.
Great. Okay. Well, thanks, Zach. Talk to you soon.
Thanks so much, Derek. Enjoyed it.